Hello everyone, this is Advocate Preeti Acharji and today I'll be teaching the concept of legal notice. In this video, I'll be teaching you the art of drafting legal notice, the sequences that need to be followed, and what are the other requisites to draft a legal notice. So to start with, we'll first discuss that what is a legal notice. So a legal notice can be said to be a formal communication where a sender or the person who has been grievant send a notice to the other party where they specify about his grievance, violations, or any breach of obligation that has been done by the other party, and provide an opportunity for the other party to make a settlement before initiating any legal proceeding. So, in basic language, we can say that legal notice is a mechanism to settle legal dispute before going to the court. So now we'll see on what condition a legal notice is required. So first, breach of contract, property disputes, recovery of any money, employment dispute, consumer complaint, family or marital matters like divorce, maintenance, or restitution of conjugal rights. So these are some of the common condition or common situation where a legal notice are being served to the other party. So if you see in the PPT, we have specified the purposes that firstly it set the stage for legal actions, then it offers an opportunity to settle dispute amicably, then third it established as legal evidence to further shown in the court if the person doesn't comply with your legal demand. Then the state can be also specified to the court that a try for amicable settlement was done by the party, however the other party didn't respond to the same. So now we have to see that what are the legal frameworks that governs legal notices in India. Now, firstly, Indian Contract Act 1872, where legal notices are issued in case of breach of contract, termination, or demand for specific performance or damages. Further, then there is Section 138 of NI Act, where a notice is sent to the other party for specifying that a check that has been given by them has been dishonored, so that they had the opportunity to issue another check to the other party, and if in case within 30 days the other party doesn't reply, the sender of the legal notice has the right to go to the court claiming under Section 138 of NI Act. Then there is Section 80 of CPC, which mandates that whenever you are making a government as a party to your legal dispute, you are obliged to send notice under Section 80 of CPC to the government authority before filing of your cases in court. Then there is Consumer Protection Act, where in order to suppose if there is a consumer who has been aggrieved by the services or the good provided by the by sellers, then the consumer has the right to give legal notice to the seller, asking them to refund or reimburse the amount that has been paid or to correct whatever has been violated or further. Then there are other statutory areas like the Transfer of Property Act, family laws. Under family laws, if there is notice, the husband can notice the wife for restitution of conjugal rights. Then for divorce, notices are also being filed. Then there are labor laws where the employer can send legal notice to the employer, or the employee can send legal notice to the employer if in case the salaries are dues, or in case of the employer, if the employee has breached some of the policy of the company, then in that cases also notices are given under labor laws. Then there are company laws, recovery matters, where notices are being sent to ask the other party to reimburse the amount before initiating any recovery suit against the particular person. So how the legal notice is structured. So it starts with the headline, dates, then the sender details, further date of notice, then the subject line, then there will be a statement of facts where you will be specifying the facts of the cases, like in this or that date a contract has been signed by both the parties where they have agreed on certain clauses. However, on the ongoing transaction, there was a breach in the clause, and that the party is now coming for a negotiation on their terms. Then there are cause of action, like what has led to the issuance of legal notice. Then there are legal basis and violations, like on what basis the legal notice is being served. What are, suppose if you are claiming for deficiency in service, then how your facts are inclined with that shows that there is a deficiency in service, and what are the violations that has been done by the other party which has led you to serve this legal notice or to go for legal remedies in order to get your reimbursement or your refunds from the other party. Then there are relief or demands. So this part you specify that you are claiming this much of amount from the other party considering the violation that has been led because of the negligence of the other party, or deficiency in service of the other party, or unfair trade of the other party. Then there comes a time frame for compliances. Now whenever you write a legal notice, you specify over that a timeline. Suppose within 15 days or within 30 days you are asking the other party to come for negotiation or come or comply with the claims that has been demanded by the sender. Then there are warnings of legal consequences. In this section you specify that if there is a violation, of if they are not able to respond within 15 to 30 days, what will be the legal consequences that the sender is trying to take, either to approach the civil courts, criminal courts, or the high courts for remedies under writ. And then you end with the signature of the advocate. So this is the basic structure of a legal notice. We'll also deal with this part in detail in our practical training of the drafting of legal notice in the after part of the video. Now we'll come to the important legal aspects. So the important legal aspects are as specified the time limitation, like you have to ensure that within the limitation period this legal notice are being set. Some of the notices, like the notice under section 138 is a time specific notice that has to be served within 30 days of the check bounce. Then the language and the tone you have to take on record, that you have to be formal, precise, and non-abusive, because legal notice is a formal document. It cannot be considered as a document to threaten the other party, or it should not look like a, so the tone has to be formal, professional, and precise to whatever the claims are and the facts of the cases. Then you also have to specify the mode of service, like what is the mode of service of this legal notice. Either you are sending it through RBAD, or you are mailing it or couriering it to the other party. So to specify the mode of service in your legal notice. Then the most important part is that the legal notice has to be printed in a letterhead of an advocate, so that it becomes a formal document, a legal notice that has been sent by the advocate to the. So now we'll come with the drafting tips. The first is you have to be clear, and no ambiguous language should be there in your draft. You have to be specific about what you are claiming, whatever the facts of the cases, and no ambiguous claims should be written in your legal notice, or something, any unnatural things are written in your legal notice. It has to be formal, mature, and professional within the context. Then you have to ensure that the facts are chronological and accurately stated. Chronological in a way that the facts has to be like a storyteller about, suppose if I've signed an agreement, then I have to specify that agreement state. So it has to be date wise and also accurately stated. It should not be suppose as I say it as a storytelling, but it should not be in the context of storytelling. It has to be exact to the fact, but has to be in a chronological order. Then if there is a need for providing any documentary evidences, then the state has to be annexed with your legal notice, but be clear with whatever annexure you specify. Like if necessary only, then only annex the documents, or else you don't have to annex the annexures, because here only two party communication is there. It is not involving the court in this context. Now provide realistic deadlines. Now suppose some of the people might write like within 2 days you respond to my legal notice. So these are unrealistic deadlines. You have to be either 15 days or 30 days. You cannot say the other party to respond within 1 day of the service of this legal notice. That will become that is totally ambiguous in the context. Now some of the common mistakes I wanted to highlight that most of the legal notices have, like you while drafting a legal notice might specify something emotional or in threatening tone that is not valid in the context of law. Then vagueness or lack of legal grounds. Now whenever you are sending a legal notice, it has to be in legal ground. It cannot be a mere notice having vague claims and vague grounds under which you have sent the legal notice. Then inaccurate recipient details. So before drafting a legal notice or starting with a legal notice, you have to be get the details to whom you are sending. See, that legal notice is going to be served to the other party through couriers, so the address has to be specific, the pin codes has to be specific. You cannot go and search in the Google. You have to cross check with your client about the recipient details and have to specify it accurately, the details or the sender and also the recipient details in your legal notice. Then inconsistent fact or claims. As I said, facts has to be in a chronological order. So whenever you don't specify your facts on a chronological order, it become inconsistent, because you have to start from the very first date when the incident occurred and then end on the very last incident. You cannot specify anything a thing in the middle of your facts, like if something happened in 12th October, then the second line will start from 13th October, 14th October. It cannot be like you have specified something about 13th October, then again you are starting about 12th of October. So it becomes inconsistency of facts. And also whatever claims that you are claiming also has to be genuine and not exaggerated or over claimed, because sometime whenever you draft a legal notice, you suppose a compensation part, some of the advocates might write compensation of 20,000, so 80 lakhs. So your compensations, your claims also has to be symmetrical. If my claims is of 50,000, I cannot claim for a compensation of 80 lakh. Nobody or no recipient will come to negotiate on that point. It will only make your transaction more difficult and complex in that context. So whatever you claim has, or whatever is your main claim or whatever your compensation, has to be consistent with each other. Then ignoring limitation period. So what happens, like suppose legal notices is served to you, like rather than you sending somebody has served a legal notice to you. Now it's very important to reply to a legal notice, and also within the time frame. If it is specified as 15 days, 30 days that you have to respond to their legal notice, then you have to adhere to the limitation period. Now in some of the cases it happens that because of gathering evidences or gathering the fact, it might cross that 15 to 30 days. So in that case you can ask your advocate, or you can specify your lawyers, or you as a lawyer can do one thing, that you can write a formal legal notice to the other party or the advocate who has served you the notice, and you can tell them the issue that at present you're not accepting any of their claims, and you seek some time to reply or to specific reply to their legal notice. So you can by that notice you can adjust the limitation period. That's not a big deal to cover up. Then comes the legal consequences of ignoring legal notices. Now as I said, it is very important to reply a legal notice that has been served to you. So there are consequences that may lead if you ignore the notice. So the consequences are that it strengthens the sender's case. The sender can go to the court and claim that they had tried to negotiate it with the other party, but the other party was reluctant to come front and negotiate with the sender. It may also lead to an ex parte proceeding, because they can go to the court and can ask for an ex partes, and also can result to legal cost and damages. Also proof of opportunity given is also recorded. As I said, they can go to the court and state that the other party is very reluctant to negotiate the terms of the notice that has been written by the senders. Regarding the consequences, not that big consequences, but yes, there is some of the consequences or some of the advantages that the sender of the notice can take of you not replying to the legal notice in the court. So it's always better to have a specific reply to whatever legal notices that has been sent to you. Now I'll teach the practical knowledge. I've tried to demonstrate the legal or the drafting structure process of legal notice to my best possibilities. So we'll start with the first title, cause title. Here We have I've given a pasted a photo also where I've seen how the cost titles are being narrated. So you can start with to the the name of the party or the company name to whom you are sending the legal notice. Then if it is a company, then you can specify that who is the authorized representative, and also a specific address of the recipient of the notice. So this is the cost title, the first thing that you start with. Then you can write a subject line. Now I want to specify one more thing, that while writing the legal notice, the subject line or the date in a notice, so there are two formats that you can follow. The first is that is shown to the screen, where I've written a subject, like you do in your while you write a letter, we used to write the sender recipient's name and the subject line, like legal notice regarding non-payment of dues amounting this amount under an agreement dated this. So you can specify your subject line accordingly. Or in the next slide you can see that it starts with a date, then a notice written, and in below the legal notice or notice you can write it, and below you can write that the mode of service that you are writing the notice, either by registered AD or email, WhatsApp, whatever form you are trying to. And then you can start with two, then the sender details, as I've shown you in the previous slide, like to the company name, the individual name, if company, then authorized representative's name. And then you can come to the subject, like what is the purpose of this legal notice. So it becomes very indicative about the notice, like by seeing the subject matter it can at a glance can specify what the legal notice is all about. Then we'll come with opening lines of the notice. Now, so the opening lines in the notice, you can start with that sir, under the instruction of your client, name of the client. Then if it's a company, then you can name the company name, and that herein after you refer them as a client, because you cannot repeat the name repeatedly in each of your paras. So you can give it a reference that it of other, that hereafter it will be referred as my client or our client if it is our law firm or something. Then you could write the address of the sender, and that on the basis of the information that has been provided by your client, you are addressing them as under. So this is, you can see in the screen I have demonstrated the opening line of your legal notice. Line, you can start narrating your facts of the cases. So while narrating the facts of the cases, I have said you that it has to be in a chronological and clear sequence. So the sequence is very important to all the people there. If you're starting to draft a legal notice, I will suggest that you can make a list of dates and events, where you can specify the events and the dates, so that whenever you start drafting a legal notice, your sequence comes as per the chronological date that has been specified in your document. So it's a very good practice to always prepare a list of events and dates before drafting your legal notices. Now I can show you the example how you can draft it. So you can start with that my client had entered into an agreement with your company dated this for the supply of the customized package material worth rupees 3,50,000, and that my client made an advance payment of 1 lakh through NEFT on 14. So here you can also specify the if there is a specific number transaction IDs, then you can also specify the transaction ID and what date the transfer has been made, and also that the remaining amount, when the remaining amount was supposed to be paid. And then you can start that the material was not delivered within a stipulated time period. So it has to be sequence wise. Suppose during the transaction there was some email exchange between the parties, so you also have to narrate the email stories, like whatever the communication were done between the between both the parties state wise, like on 4th of August I have sent them the PO, and on 5th of August they have sent back me the signed PO, and then on the 6th I have asked them to deliver the product. So it has to be very sequence wise in your legal notice, so that your facts are clearly being demonstrated through the legal notice, and no ambiguity in regard to the facts has to be there. So after that you can specify the claims and reliefs of. Now suppose if a transaction are in monetary terms, or if you have produced some goods to them and they are supposed to make you a payment, then you can clearly make a table. Like after specifying your claims, you can clearly make a table that on this you can make a 5 or 3 columns, like the date, the amount paid, the mode of payment, and that also the date of receiving the amount. So you can make a table. You can see in the screen that there is a demonstration of a table that I have pasted in the slides. So by this way you can specifically write about your claim, so that it becomes very clear for the other party that what are the exact claims. Or even if you go further for a legal disputes, then also it is very specific that on this date the payment was done through this transaction IDs, and also whatever the remarks were while the payment was done. So you can specify it, always specify it through a table. It makes your legal notice more consistent with your facts. Now as I said that if necessary, then you can annex some evidences, but this is one of my recommended practices, that I don't specify any evidences or annexes. If there is a necessary, then you can also make an mention that relevant documents and recorded in regard to the facts are in possession to your client, and it will be produced as and when required. So this become for the first legal notice to be served, it becomes very easy or very specifically safe for the other party to not at the first produce any evidence or annexation. Because see, whatever evidence is, suppose while filing a court case you make your emails and annexes, but the emails are being exchanged with the other party, they already have your documents, so it doesn't make any sense of providing again the evidences to them. So if you want to, then you can make a mention of this line, or if it is very necessary to annex the annexure, then only you annex the documents, otherwise it's better to avoid. Now related facts to the type of legal violation. Now as I said, your facts has to be specified about whatever violation you are claiming. Suppose if I am claiming, as I said before, if I am claiming for deficiency in service, I have to show that there is a date of purchase, date of defect notice, that how the other party's behavior consists in the deficiency in service. You have to specifically show that how the deficiency in service is there, otherwise it will be an inconsistent legal notice that won't match with the violation that you are claiming. And then example 2 will be the breach of contract. If there is a breach of contract, then you have to see what clauses are being violated. You have to specify which clause has to be violated, has violated by the other party. So basically whatever legal notices or whatever facts I am specifying in the legal notice has to be in connection with the violation that I am claiming. It cannot be like I'm in my facts I'm showing that there is a deficiency in service, and then in my violation I am claiming all sort of theft and all that. It becomes inconsistent then. So your legal notice, whatever you write, whatever your facts, has to be in collaboration with the violation that you are saying in every line. Suppose if there is an incident that has specifies that there is a violation, that there is a criminal intention, then you have to end it up with a clause that this incident has led to the apprehension of that there is a violation or there is a deficiency in service or breach of contract in the context. Now the final demand and legal consequences warning. So as I said before that whenever you write a legal notice, at the end you always specify that this is your outstanding amount, that you are claiming this, and the compensation amount, and you also ask them other party to come and negotiate or come to an amicable settlement either within 15 days or within 30 days. So this will be your ending notice. And further you can also specify that if in case this this is not followed or the limitation is not carried on, then what are the consequences or legal consequences that the sender is willing to take, either going to the court, legal proceedings, civil, criminal, and also there is a basic line that you write that whatever legal proceeding will be conducted, it will be at the cost of the recipient of the legal notice. Now the closing and the signature. So you always end the notice with your sign as an advocate and also the seal of the advocate. So this is the basic practical training I've tried to demonstrate it through pictures and all. One of the thing that I want to specify that see, drafting is a thing that you have to understand after your practical practice of drafting legal notice. So this is just a roadmap of how you can start drafting a legal notice, but the only way to learn drafting would be by actually drafting the legal notice or actually working on the field. That will make your concept more clear, and these are the points that you can keep on mind, so that whatever you draft is consistent with the principle of legal notice, or the demand for legal notice is. So I'll conclude that legal notice are considered as the first step for legal redressal. It is a way to simplify or a pre-court procedure, so that both the parties come and settle the matter. So it's very important that whatever you draft, it doesn't look like a threatening to the other party, or should not get the other party aggrieved. Like you cannot use languages that aggrieve the other party, because that will always forfeit the purpose of serving the legal notice. And further, that a well drafted notice should avoid prolonged litigation. So whatever you are drafting should not be in an intention that you are going to the court. It has to be in the intention that there has to be an amicable settlement through this court, because it is a very first step for legal redressal. So it's better that it's always better for the parties to, before going to the court, amicably settling the matter. Then that whatever legal notice you are doing, it must be done with legal clarity and strategic intention. So as I said, legal notice, a formal document, a professional document, it cannot be inconsistent, cannot lose the basis of law or the logic, and it has to be within a strategic intention of the advocate before drafting the legal notice. So that's all about legal notice drafting. I like to thank you for patiently listening to this video. Also, for any other further legal tips, you can let us know in the comment section, and we'll further also provide a detailed video in each of the topics that you are required in. Thank you.